music. And joining us now in the studio, our friend, the director of the Mississippi Justice Institute, Aaron Rice. Morning, Aaron.
Morning, Gerard. How you doing?
Well, it hadn't had a lot to think about.
Yeah, there's plenty to digest here. I said it earlier. We could talk about this all day and not get through it all.
Well, we wanted you to come on. Suggested that Alex reach out to you.
Yeah, appreciate that.
She and I are talking about that over the weekend.
I know this all happened quickly. This opinion just came down Friday, and so things kind of get in motion quickly.
Well, I'm sort of retired, and so when I exited the show Friday, I went out to enjoy some golf, but I used my whole battery on my phone blowing up. So anyhow, appreciate you coming in. I have hesitated, as I was telling you before we came on the air here, to offer too much in the way of, I guess, legal opinion, because I freely admit I'm not a lawyer. And this is complicated. I think this is deep. I think I do understand, however, the purpose of the various branches of our government. And I know you heard me talking before we went to break there that we don't want the judicial branch ruling in accordance with the will of the people. We want them ruling on applicability of law and interpreting law. That's their purpose. That's their scope.
That's exactly right. And I mean, look, you can agree with this opinion or disagree with it, and there's plenty. And the Mississippi Supreme Court was in a tough position here, and there's plenty to agree with or disagree with on either side. But you're exactly right that it is certainly not the job of the Mississippi Supreme Court. I've heard that too. That they overrode the will of the people. That their job is not to bow to the will of the people. If they started doing that, it would completely erode our entire system of government. That's, just as you've said, that's the legislature's job. When something gets in front of the court, its job is to interpret the Constitution or to interpret whatever statute is in front of it. But it is not to look and say, well, how popular is this? How many people like this? I mean, if we start doing that, our entire system of government is going to be in jeopardy. So that's not what they're supposed to do. Actually, in a lot of ways, the courts are inherently an anti-majoritarian institution of government, and the founders wanted it that way. So let me give you an example. I mean, our rights are too important to be subject to the whims of popularity, and so they wanted the courts to be the bulwark that protected that and said, look, it doesn't matter how many people. I mean, any statute or a law that's passed is you're going to assume is popular. And so if the Biden administration passes some law that's going to make it impossible to own a gun or to exercise some right, it doesn't matter how popular that is. The founders wanted the courts to be able to say, we don't care how popular it is. You're violating people's rights. You can't do that. The Constitution says you can't do that. We interpret the Constitution. That's what we do. Yeah. And so I know here, people feel like they kind of lost something that they wanted, but you've got to zoom out and look at the big picture, which is you want the courts to interpret the Constitution and not start getting into how popular is this or what do the people want. And in this case, unfortunately, the way, the majority read the law, they decided that this is what it meant, that the ballot initiative was unworkable now. And again, you can agree or disagree with that opinion. I mean, I don't know that it's exactly the opinion I would have issued if I was on the Mississippi Supreme Court, but I respect the opinion. I think the Justice Coleman and the other members in the majority had very solid legal reasoning for reading it the way they did, and they backed it up. And agree or disagree, that's their job.
We get into this a kind of controversial debate about words matter and text and strictly adhering to the text versus intent, which is you hear a lot of folks saying. I haven't read the opinions and not sure I'm qualified to, honestly, but so what the intent, I think, of the legislature was to have a citizen-initiated ballot measure process since 1992 when that was instituted. And
exactly.
Is that incorporated in the Constitution?
It is. It's in our state constitution. It has been since 1992.
And was that was that included in the Constitution via legislative action?
I believe the legislature, amended it to include this citizen portion of how it could, going forward, citizens could lead a ballot initiative.
Because wasn't there a long stretch of time, Aaron, where there no such opportunity existed?
That's right. I mean, this is not a right that we've always had in Mississippi. We've had it since 1992.
Okay. So 1992, they stuck this in the Constitution. And then, lo and behold, we find out once we converted from 5 to 4 congressional districts, we really don't have a way to achieve a valid citizen-initiated measure.
Yeah, and you're right. You're keying in on exactly what was going on, this kind of textualist approach, or really when you're dealing with the Constitution, you can call it strict constructionism, and sometimes textualism is used when you're interpreting statutes. But this is a very big, really judicial kind of philosophy, kind of war of different philosophies that are going on that a lot of people may not really be cued into, that kind of behind-the-scenes battle. But there's one kind of branch of thought that says, we've all heard it, kind of this living constitution or kind of legislative intent is a phrase that's thrown around a lot. And it basically says, like, hey, let's judges, not just look at what the words on the paper say. Let's look at what do we think the legislature meant, or what do we think the founders or the drafters of this constitution meant? What do they want? And that can get dangerous when you start going down that road. The courts can basically make the Constitution say whatever they want it to, or a statute to say whatever they want it to. And then there's another camp that is kind of called originalism, and we've all heard of that says, let's look at what the original intent was, or sometimes the original public meaning, but let's not, get into what we think today, what makes it workable or any of that. Let's look at what did it mean to the people who drafted it or to the citizens who ratified it and things like that. Yeah. And so another branch, even kind of further, I guess you could say, to the right of originalism is this kind of strict constructionism you're talking about. And it's saying, let's not even look at what the original intent was or the original public meaning. Let's look at words on paper. What do they mean? It's a very boring kind of judicial philosophy. It's basically like going to English class. Very boring. You look, adjectives and, different types of, pronouns or this or that, and you put it together and say, this is what it means. Now, if you're following that approach, what you say is, if I can read this sentence and it's not ambiguous, then I don't need to engage in any other kind of judicial construction to figure out what it's telling me. And that's what the justices did here. They said, I read the words on the paper. The words say that you can only get up to 1/5 of the signatures from each congressional district. That's impossible now because we only have 4. Right. So it's not workable. And they stopped there. And look, they could have. There are judicial methods of saying, well, for example, one is to say, if we're going to read the Constitution, we're going to assume that the drafters of it wanted it to work, and if our interpretation is absurd, we're not going to stop there, and we're going to try to figure out another interpretation that doesn't yield an absurd result. And they could have done that, and they could have said, look, by Mississippi law, we technically still do have 5 congressional districts. They're just not recognized at the federal level. There's kind of this judicial injunction, if you've heard of this, that forced the 4 districts on us. But under the Mississippi Code, we still have 5. Yeah. And you could have kind of gone down that road and said, well, look, this is an absurd result. Surely the founders or the drafters of this constitutional amendment did not mean for it to get outdated if we lost a district in the census. And so we're going to go past that and look at other ways to kind of save this provision. And they could have done that. But they chose not to. And it's certainly an approach that they were, that they could judicially take, and that's the route they took.
Well, and I think what you're suggesting seems logical. But on the other hand, Aaron, we had 7 bills that were filed to cure this problem that all died. So that kind of makes you wonder, right, what the will of the legislature is here.
Yeah, exactly. And, of course, you're talking about the present-day legislature or the legislature at the time as it existed that those 7 bills were passed, which is different than the legislature that existed at the time of this constitutional amendment. So you get in all kind of questions. But I do think the court looked at that, and one of the things that the majority opinion said was, look, for all we know, the drafters of this constitutional amendment wanted it to get outdated, for all we know. Maybe they contemplated the fact that we might go down to 4, and they were glad that maybe this would get outdated. So but that does kind of expose the problems of when you start trying to get into the heads of the drafters. Sure. How do you know what they were thinking?
Sure. Don't really know. It does, however, seem to be, I think, kind of fairly broad sentiment. Would you agree with this? I'm going to ask you if you agree. Broad sentiment that members of the legislature, lawmakers in general, feel like that's their scope. That's their area.
I think so. I've kind of sensed that before, that this kind of direct democracy, so to speak, they feel like it can cause problems. And look, you trust us, you hire us to come here and make general law for you. And when citizens try to get in the business of making general law, there's going to be problems. So y'all just sit tight and let us handle that. I think there is a little bit of that feeling.
I think so, too. We got a break right here. You ain't going anywhere.
No, though. I'm good.
Right, we got Aaron Rice with the Mississippi Justice Institute. Stick around, folks. Good conversation about all the legal unpacking here of Initiative 65. We were talking about Initiative 65 and all the legal complexity surrounding that. By the way, Chris from Oxford, lots of text. I'm sorry, folks. I'm trying to leverage Aaron's time while we got him in the studio. So much to discuss.
Yep.
Chris from Oxford says, y'all are giving our legislators too much credit. Okay. Yeah. Appreciate that.
I don't know in what regard. Exactly. I mean,
all right. So this is the question that has immediately surfaced, as you're well aware, Aaron, when the Supreme Court struck this deal down, because they said, hey, this approach and these standards for collecting signatures to get a measure on the ballot as initiated by the citizens, it can't work mathematically. Yeah. So what does this mean to previously passed measures at the ballot box? Voter ID, eminent domain come to mind.
Yep. Those are subject to the same kind of lawsuit that happened here now. They're very vulnerable to being struck down, just as this was. And if I were to make a prediction, I would say that they will go down as well. Now, we can talk about it. Voter ID has also been put into the Mississippi Code, so it's got a little extra protection there. But in terms of, the constitutional amendments that were put into our Mississippi Constitution, I think both of those goes down. There's some arguments you can try to make that were made in this case too, and you can try to make there to try to save those. But just predicting it, I would not think those would help.
That would require separate lawsuits,
that's right?
That's the big question, and I want to make sure we got that right. That just because the court only considers what's before it.
Exactly.
You made that statement before. So there's not a matter before the court
That's right.
to rule on the validity of those two.
That's right. So just because the court said this ballot initiative process is broken does not mean that anything that passed since 2002 is just automatically struck down. That's not the way it works. What was in front of the court was, Initiative 65. It was basically struck down, if you want to put it that way. But somebody would have to bring to the court proactively and say, hey, now consider, you already said this system was broken. This same system was used for eminent domain. Take a look at this. And the court, much more likely than not, the same reasoning will hold, and they'll say, yep, this is invalid too now.
Yeah. My concern is if a party... the ACLU comes to mind, that might have an interest in striking down and reversing our voter ID statute. If they come forward and do that, we would get national attention.
There would certainly be national attention. And you said our voter ID statute, and that's a good point, is that's one thing that makes it different, is that it was voter ID. There was a citizen initiative just like this, and it was put into the Mississippi Constitution, but then the legislature also codified it and put it in Mississippi Code. And so the constitutional provision for voter ID is subject to this same attack, and a lawsuit could be brought, and the Mississippi Supreme Court could say, that system that was used was invalid, so that no longer applies. But you would also have to bring an attack against the Mississippi Code, the codified version of our voter ID law. And there you would not have the benefit of just saying, the process was defunct. You would have to bring constitutional arguments to say this law, unconstitutionally puts too many burdens on the right to exercise your franchise, your right to vote. And, whether the merits of that case would work out are a lot different. I mean, that hasn't been litigated. There's no briefs to read on that yet, but you would have a whole different can of worms to try to bring that down.
I'm going to make a point about what I know from contractual law, being a contractor in business, which is when you implement these sophisticated IT systems, you would often have end users that would not want to pay in full. Even though you had no retainage provision in the contract, but they were using the system. And my lawyers always said, use is acceptance. If they're using the system, they either got to pay or they got to stop using it. And if you suggested stop using it, no, we got to have it. Well, then we got to get paid. So make that same case for what happens when a law is codified, such as voter ID, and it's been applied. We've been using voter ID for years. There's a legal concept about that as well.
Well, and so I think what you're probably thinking of is called laches or lashes. People call it, pronounce it different ways.
LATCHES.
That's right. Yes, and so there's and I think the T is actually out, but no T. But it's just a legal concept. What it really comes down to, what it means is you can't sit on your rights.
Okay.
And if you sit around on your hands and don't do anything about some injury that's happened to you, and this is outside of the constitutional context, it's all over the law in any setting. I mean, if you and I are in a lawsuit and I waited for years, and there's also things called statutes of limitations that may apply, but outside of that, even if there's not a statute of limitations, if I sit around and wait 15 years and then all of a sudden say, hey, Gerard, I'm mad at you and I'm going to sue you, you could say, whoa, you've waited way too long. You should have brought this a long time ago. So that argument was used here, too, unsuccessfully. And I think the government, in defending these prior initiatives, will use that same argument and say, you waited too long. Honestly, I don't think it'll work. I mean, when you're in the constitutional setting, first of all, you have to not only show that they waited too long, but show that them waiting that long injured you. And so the government will have to say, look, this has injured us. And I think it's hard to show an injury to the government. The government needs to operate constitutionally. And if you're saying you've been operating unconstitutionally, that's not really an injury to the government. And then, on top of that, every day that a law exists that's unconstitutional is kind of a new injury to the person, who's allegedly suffering from that. And so I think they can say, look, we're still suffering from this alleged unconstitutional, voter ID thing. We're going to suffer it in the next election, and that's going to trigger a whole nother injury to us. And it's fresh for us to bring this, and so. I don't know. It's going to be hard to figure out is there kind of a triggering event. And that's another argument any plaintiff could bring is they could say, we just learned, last Friday that this ballot initiative process was in fact, problematic and unworkable. And so that's why we brought these lawsuits now against eminent domain and voter ID is because we just learned this. Yeah. So I think it will be hard to save those based on that laches argument, but we'll see.
Yeah. I don't know. It's got more teeth in it, I would say, certainly at this point. Yeah. But I do think it would draw national attention. Yeah. Speaking of which, going to pivot for a second. Okay. This just was announced that the Supreme Court of the United States here is going to take up Mississippi's abortion ban bill, 15-week deal. Haven't dug into the details on that. Yeah. What do you think?
Yeah, I haven't been able to dig in either. It just happened, but I think it's going to be very interesting. I mean, we've known that this was coming for quite a long time, and I think a lot of people feel like, this is conservatives that waited till they got a majority on the court and then started pressing this, and there's certainly I think there's been a lot more interest in pressing that issue, but at the same time, the science has been evolving for a long time here. I mean, Roe and Casey are very old Supreme Court precedents, and they dealt a lot with viability, and that the state didn't have an interest, according to the United States Supreme Court, in banning abortion, before viability and things like that. But now, as science has evolved and we know more about, babies in the womb and all that kind of thing, where is that line of viability and what does that mean? And so that's kind of, again, I don't want to claim to be an expert on this issue because it's just popped up and, we don't all know what all the details are going to be yet. Yeah. But it'll certainly be interesting because what you're seeing is states, not just Mississippi, but Mississippi is one of them, are, kind of trying to move the needle on Roe and say, look, the U.S. Supreme Court said that states do have an interest in protecting life, and viability was kind of part of that. And we're trying to move the needle on what is viability and how much of an interest does the state have? How far can the state go in protecting life? Yeah. Before apparently the U.S. Supreme Court will say we can't do that. And then you never know. I mean, there's always the possibility that Roe gets completely overhauled or reversed, or and there's a new precedent in its place.
Yeah. So. Also wanted to ask you this, I forgot about this, about I-65. What about the banking situation that comes up? Tell us about that. Yeah,
I mean, well, under federal law, as you can imagine, under the Controlled Substances Act and other such statutes, you're not supposed to be able to deal in drug money. And so at the federal level, marijuana is still illegal. And so there's been this long kind of struggle between, there's legitimate businesses out there that are operating under various state laws that allow medical marijuana or even recreational marijuana, and they're taking money in, but sometimes banks won't even, hold an account for them because under federal law, this is drug money, that they're not supposed to be able to do. And so there's been efforts to fix that over the years. It's really, I'll just say, this situation we're in is untenable, where the federal government has something illegal and 2/3 of the states or something now at this point have some form of it that is legal under state law. I mean, we can't go on that way, and it's undermining our Republican form of government. It really is respect for rule of law, all that. Yep. We need to get on the same page a lot more.
You could apply that to lots of other matters as well, guns and voting and all that sort of stuff.
Yeah.
All right, we are done. I'm exhausted. Appreciate you coming on.
Talk too fast for you.
No, that was fantastic. Appreciate you unpacking a lot of that. Thanks, Aaron.
For sure. Good talking to you.